The doctrine of res ipsa loquitur allows a jury to infer a defendant's negligence from the mere occurrence of an accident. In Giles v. City of New Haven, the court explored what plaintiffs must show for res ipsa loquitur to apply. Louise Giles was an elevator operator in a building in New Haven, Connecticut. Otis Elevator Company had installed the building's elevators and was responsible for inspecting and maintaining them. One day, when Giles was ascending in the elevator's compensation chain became hooked on a bracket in the elevator shaft. The chain was bolted underneath the elevator cab, and Giles couldn't access it from inside the cab. The elevator started shaking, and Giles's head and shoulder hit the cab wall. Giles jumped out of the cab on the closest floor and suffered additional injuries. Giles sued Otis and the city in Connecticut State Court, alleging that Otis negligently failed to inspect, maintain, and repair the compensation chain. At trial, Otis's maintenance supervisor testified that the chain wasn't regularly inspected or tested. But he also testified that a compensation chain could only hook onto a bracket if the chain swayed excessively. He believed that excessive sway was caused by improperly operating the elevator, including rapidly reversing the elevator's direction. He testified that he'd previously seen Giles rapidly reverse directions while operating the elevator. The trial court directed a verdict for Otis, but the appellate court reversed. The court held that the jury should have been allowed to decide whether Otis was negligent under a res ipsa loquitur theory based on the circumstances of the accident. Otis appealed to the Connecticut Supreme Court.